Thanks for joining us here on 9 News Plus. I'm Chris Bianchi.
And I know there are millions of Americans in this country who feel disappointed and discouraged or even a little bit angry about the court's decision today on student debt.
I am looking forward to creating consistent with what I believe and what my faith teaches me about marriage.
The U.S. Supreme Court wrapped up yet another fairly contentious term in late June with some high-profile decisions on student loans, affirmative action, and several other high-important topics, and in some cases may have permanently altered the American way of life. And for a bit more on some of those decisions and a bit of a look from a broad perspective in terms of what we saw, we're now joined by 9 News legal expert Whitney Traylor. And Whitney, I guess from top line overview, what were some of the big decisions that came in from the Supreme Court term, and how could those alter American life?
Well, there were so many this term, and particularly at the end of the term, even the last day. And so certainly one of the bigger ones was the case dealing with affirmative action and essentially overruling precedent from starting in 1978 with Bakke that did say race could be considered a factor into 2003, and now they've essentially reversed that precedent. So that's fairly significant. Obviously, they just ruled on the student loan forgiveness, and they said that President Biden's plan was unconstitutional. He didn't have the authority to do it. So that's been overturned. So that's going to affect millions and millions of Americans. Certainly the website designer, that case that originated out of Colorado, and in that case, the website designer preemptively, she didn't want to design cakes for LGBT or same-sex couples, essentially saying this is my artistic expression, and forcing me to do that is compelling speech in violation of my First Amendment right. And the court said yes. That case is going to have significant impact because you're now going to have people who say, my business or my service is my artistic expression. I'm a cake baker. I'm a website designer. I make posters. And if they say, I disagree with this, a same-sex marriage, a certain religion, interracial marriages, things like that, they can now use this case as precedent to justify not providing that service. So I think that case is going to have very serious implications.
That said, earlier in the term, and I think you kind of alluded to this, there were some decisions that may have been a bit unexpected in terms of how they were ruled. I'm kind of thinking about the Native American adoption one, for example. I think there were a couple others that were, again, maybe 5-4, with a couple of the conservative justices ruling with the liberal justices. So there was maybe a bit more of a moderate streak, or perhaps that illusion of one, and then that kind of swung pretty hard to the right, I suppose, by the end.
On some of those issues, for sure. And I looked at, and I have notes on 6 or 7 different cases, and there were cases that were 5-4, 6-3, 7-2, 8-1. So it was somewhat over the board. The cases I just cited, the ones that are dealing with some of these kind of important social issues, were divided 6-3 based on political lines, the 6 conservative justices. But many times Chief Justice Roberts will join the liberal justices, and he's done that historically to even out the court in some instances. But here there were several that were 6-3. But yeah, you mentioned the Indian Child Welfare Act, and essentially the court upheld ICWA, saying that yes, Native American family members will have priority in adopting because that originated from Native Americans and the I guess white culture having a plan of assimilation, trying to get the Native Americans kind of trying to whitewash their history. And so that's the purpose of ICWA. And even now the court, notwithstanding this affirmative action, saying, hey, we don't think that this is necessary anymore to reverse these discriminatory acts against black people. But with ICWA, they're saying, yes, we still think the Native Americans need to have priority in the adoption.
Were any of these cases that came out, were any of the results surprising to you? I kind of think back of student loan forgiveness, about that being 6-3. I don't know, did any of them stand out in terms of surprise?
Yes and no. And I say yes because some of Chief Justice Roberts' focused on precedent. And so some of these cases, they overturned precedent, like I mentioned with the affirmative action, for example. And so I'm surprised in that regard, but on the other hand, I'm not surprised. This is a conservative court, a very conservative court. I think that is the primary legacy of President Trump is his 3 Supreme Court justice appointments, because all 3 of them are very conservative and very young. So this is going to be, unless there's eventually term limits put on the Supreme Court, which some people are floating around, if that doesn't happen, which I don't suspect that would happen anytime soon, we're going to have a conservative court for years and years. And you have to remember the president also appoints all the federal judges, not just on the Supreme Court. So there's hundreds of federal both trial and appellate court judges, which President Trump also appointed many conservative judges, and they're also young, 30s, 40s. So the landscape of our legal landscape has shifted conservative since his presidency.
Do you expect overall this kind of conservative, and I know some people have described it, I guess I'll ask you, would you describe it as an activist conservative court in the sense of intentionally interpreting the law in a conservative manner to push forward conservative policy goals? Would you describe it that way legally based on what you've seen?
Yes, I would. I think that's a great question, because when you think about an activist versus pacifist court, so some people, you hear this on the Sunday morning shows, and so a pacifist judge is one who says, look, our job is to just interpret the Constitution. Is this particular law that Congress passed constitutional or not? If it's not a question of constitutionality, essentially we shouldn't get involved. So shouldn't get involved on some of these social issues is the argument. An activist court or an activist judge is one who wants to accept writ on all these different issues and rule on them. And so generally, conservatives are saying we want a more pacifist court. But I would agree with you that this is more of an activist term in that they picked up these very significant cases, and including overturning Roe with the Dobbs decision. You know, and these are years and years of precedent overturned in really one term.
Are there any cases that you see that could be struck down or perhaps chipped away at by legislation? I kind of think about, for example, the student loan forgiveness. I think about the Colorado web designer who didn't want to serve that. Again, even affirmative action, could that be kind of whittled down in terms of its scope and how it's carried out?
Yes, it could be, and I suspect it will be, because you have to look, our system is a common law system, so also known as precedent or stare decisis, judge-made law. This all essentially means the same thing. So we enact a statute, Congress passes a law, and then the courts have to interpret that law. So, of course, Congress can't say every potential factual situation that may come up. So that's why as litigants, as people come to court and have trials about their cases, we start to develop the law and get a body of laws. So here, let's say on the affirmative action case, the court said, historically, the precedent was you could consider race as a factor, just like you can consider legacy if you're a son or daughter of somebody who goes there. All of these factors that schools can consider. They can consider first-time college student. Were you raised on a farm? If you have athletic skills, if you have achievements in science. All of these sort of subjective things are incorporated into the admissions process. Now, the court has said, well, race can't be considered a factor. But they did say, Chief Justice Roberts, in his opinion, he did say that, well, you can, if the student mentions race in their essay and it's a point of pride or they had to overcome some discrimination, then they can sort of consider that, if you will. So that's still sort of a subjective, nebulous standard. So you're still going to see, as schools try to both maintain and increase diversity and comply with the Supreme Court, you're going to see schools implementing policies that will get challenged. And so then they'll ultimately sue, the Court of Appeals will rule, and we'll start to develop our body of law based on all of these cases put together. So I think, yes, there's going to be a lot of cases that are, this is going to lead to more litigation, certainly with the Dobbs decision, reverting abortion rights to the states. Now you have all these different rules and laws dealing with interstate commerce and all this other stuff. So there is going to be a lot more litigation, and especially on the website case, because now there's going to be a lot of business owners that are going to say, hey, I don't agree with whatever these people are doing, their religion, their language, their sexual preferences or whatever. So I'm going to refuse them service because that's, I don't want to be compelled to promote their message. And that's just going to be, there's going to be significant litigation on that because people are going to deny it on everything: interracial marriage, same-sex marriage, Muslims, whatever.
I guess from kind of wrap things up a little bit here in terms of a broad perspective about Chief Justice John Roberts. I know he's always prided himself, and I think the court, on being, he's an institutionalist. He wants it to be seen as a fair arbiter of law. Do you think, and based on some of these decisions and the fact that we did see quite a bit in the way of ideological tilting here, that A, he's concerned about that, and B, that he's trying to perhaps rein in the court at all? Are you seeing any signs of that, or what's your thought?
I mean, I would say yes on the one hand, because he's made that known in speeches and otherwise, and he's sided with the liberal justices from time to time. But now, in some of these cases, it's very clear when it was divided 6-3 that he's not taking that role of arbiter or trying to bring people, having a sort of modified kind of center, if you will. He doesn't seem to be doing that, and it's a problem because it was just recently that the majority of Americans now don't have confidence in the Supreme Court, that they're objective and what have you, and a lot of that stems back to the confirmation process, which is extremely partisan, extremely polarized. It's all televised, and everybody's being as bombastic as they can. And now it's completely becoming ideological on the Supreme Court. And you can look back to Justice Scalia and Justice Ginsburg, very liberal and conservative justice. They were confirmed almost unanimously. And that was just, back in the 80s and 90s. And so now you have the most recent confirmations almost completely coming down partisan lines. And that, I think, is creating this sentiment in the country that the justices are partisan and politicized. And that's a huge problem, because as long as we have conflict, we're going to have conflict in this country. I think it's inevitable. Disagreements, polarizations in some regard. But if you don't trust the arbiters, the people who are there to decide these, if you don't think they're fair, that really erodes at the rule of law.
Any big court cases to potentially look forward to in 2024?
Oh, there's a number of cases that are coming up, and let me see if I can pull them up on my notes. There's one that's interesting, a lawfare case, and this is whether a civil rights tester, so somebody who goes in with a disability and goes into a facility to see if it's ADA compliant. They're saying that that tester, historically, the question is going to be, will that person have standing under the ADA? So that's going to be decided. That's going to be pretty significant. There were a number of racial gerrymandering cases this term. There is another one dealing with South Carolina congressional map, so racial gerrymandering continues to be an issue.
And it was North Carolina and Louisiana, right, that were just decided. And
Correct.
where the conservative justices, I believe, voted with liberal ones.
Right, on the independent state legislature idea, which said, hey, state legislatures should be able to control all facets of voting in an election, even federal elections, and they can't be sort of supervised or ruled upon by state or federal courts. The Supreme Court rejected
Through that, yeah.
Right. And then there's another case that's going to be accepted next term, which is whether a public official's social media activity can be considered state action. So we saw that with President Trump and with Lauren Boebert, Congresswoman Boebert, when they would block people on their social media. And the question is, well, if you're performing official government state action, you can't block people because that is the right of free speech. And so they're going to get some more parameters around that. So there is some interesting cases for next term as well.
Fascinating. Well, I'm sure you'll be with us for those as well. So 9 News legal expert Whitney Traylor, we appreciate a few minutes of your time and lending us your expertise about this contentious court term.
Yes. Yeah, good to be here. We'll see what happens next term.
Thanks, Whitney.
All right.